Back in 2016, India rolled out a massive economic reform, one that pretty much changed the entire rulebook for businesses across the country. It's called the Insolvency and Bankruptcy Code, or IBC for short, and it totally redefined what happens when a company gets into deep financial trouble. So let's break down exactly what it is and why it's such a big deal. It's a huge question, right? One that can ripple through the whole economy. Before 2016, the answer in India was, well, a mess. It was slow, it was complicated, and honestly, it was pretty destructive for everybody involved. The IBC was designed to fix all of that. All right, so here's our game plan. First, we're going to look at the tangled web that existed before this new code. Then, we'll dive into the 2016 game changer itself. We'll clear up a couple of key terms you absolutely need to know, walk through the high-stakes resolution process, and then finally zoom out to see the massive impact this all has. To really get why the IBC was so revolutionary, you have to see the chaos it was meant to clean up. The old way of doing things was, to put it mildly, a legal jungle. I mean, just look at this. Before the IBC, you didn't have one law. You had this confusing patchwork of laws, some of them over a century old. Imagine your lender trying to get your money back. You'd have to navigate this maze. It just led to endless, and I mean endless delays. And while everyone was stuck in court, the value of the struggling company just withered away to nothing. So, to fix all of that, in comes the Insolvency and Bankruptcy Code. Think of it as a single, consolidated, modern law built for a new era of the Indian economy. And its goals, which are laid out right there in the preamble, are really ambitious. See, this isn't just about shutting down failed businesses. It's about maximizing the value of whatever is left, which could mean saving the company. It's about encouraging people to take risks, to be entrepreneurs, by giving them a clear exit strategy. And that, in turn, makes banks more willing to lend. It's a delicate balancing act. Now, to make a huge reform like this actually work, you need a whole new ecosystem. And the IBC is built on these 4 pillars. You've got special courts to hear the cases, a powerful regulator, the IBBI, to set the rules, licensed professionals who actually manage the process, and information utilities that store all the financial data. Together, they create a trusted and professional framework. Okay, before we go any further, we need to pause and get 2 really important words right: insolvency and bankruptcy. People use them interchangeably all the time, but in the world of the IBC, they mean very different things. So, insolvency is a financial state. Think of it like a diagnosis from a doctor. A company is insolvent when it just can't pay its bills on time. It's a situation, a problem that needs a solution. Bankruptcy, on the other hand, is the legal process. It's the formal, court-driven procedure that gets triggered because of insolvency. It's not the problem itself, it's the legal conclusion. This quote just nails it perfectly. An insolvent company isn't automatically bankrupt. Not yet. There's still a chance to fix things. But a bankrupt company is one that's already gone through the legal process. That distinction is key. And that distinction is crucial for understanding the real heart of the IBC, what's called the Corporate Insolvency Resolution Process, or CIRP. And as you're about to see, it's a process that is literally a race against time. The absolute best way to think about the CIRP is like a financial emergency room. When a company is in trouble, the goal isn't to declare the patient dead on arrival. No, the goal is to stabilize them, figure out what's wrong, and find a path to recovery. Revival is always the first choice. So here's how this financial ER works, broken down into 4 steps. First, someone, usually a creditor who's owed money, kicks things off. Second, a moratorium begins. This is huge. It's a calm period where all other lawsuits are frozen. Third, a committee of creditors is formed to take control and look at plans to revive the company. And finally, they either approve a rescue plan, or if a revival just isn't possible, the company's assets are sold off. And here is the truly revolutionary part. This whole process, start to finish, including all the legal battles, has to be done within 330 days. That's it. Speed is everything. This strict deadline is what prevents those endless delays that destroyed so much value under the old system. So we've gone through the process, but let's zoom out. Who does this actually apply to? And what's the real big picture impact on the economy? Well, the code's reach is incredibly wide. It's not just for giant corporations. It covers LLPs, partnership firms, and even individuals. And this is a big one. It also covers personal guarantors who backed corporate loans. Suddenly, everyone was playing by the same clear set of rules. The real superpower of the code comes from this one simple provision. It has an overriding effect. That just means if there's a conflict with any of those older laws, the IBC wins. End of story. This one rule cuts right through that tangled legal web we saw earlier, making sure the process is clean and decisive. Ultimately, it all comes back to this. A clear, fast, and predictable way to handle failure isn't just about collecting debts. It gives entrepreneurs the confidence to take big risks, and it gives banks the confidence to lend them the money that fuels economic growth. And that leaves us with a final thought to chew on. We tend to look at bankruptcy as failure, as the end of the road. But what if a system that handles it quickly and cleanly isn't a sign of weakness at all? What if it's actually the hidden backbone that allows a modern economy to be truly dynamic, to innovate, and to grow?